Okay, so I'm actually making this video at the request of Matt Kors because there's been some confusion regarding what happened in January regarding the shutdown of the trading on AMC, GME, BlackBerry, Express, and COS. I know that there was testimony in front of Congress that the NSCC increased margin requirements, and that was why Robinhood claimed that they shut down, but a class action lawsuit was actually filed on April 30th against Apex Clearing Corp and Interactive Brokers. Apex Clearing Corp is a New York corporation headquartered in Texas. Interactive Brokers is a Delaware LLC. They actually went through the trouble of listing out the stocks as well as the brokers that use Apex Clearing Corp. They brought the action pursuant to federal law, Section 10B of the Securities Exchange Act, which is 15 U.S.C.A., Section 78 JB, and Rule 10.5 of the SEC. They brought it from the Class Action Fairness Act of 2005. That's 28 U.S.C. Section 1332 D2A, meaning there's more than 100 members in the state where first I should explain the class action. In order to have a class action, you need to have at least 100 people that are similarly situated, meaning they all suffered a similar harm by the same defendant. It's either similar or same ongoing course of conduct, and one individual can represent all of those individuals. There has to be at least 100 of them. But the funny thing about it is, even after you've had the case filed and the class certified, and you can only do it in federal court, it's a federal statute, you can continue to bring in more class members that are similarly situated. So because they're alleging an allegation of a violation of a federal law, they have federal jurisdiction, but also because so many of these class members who were violated by their brokers who are using Apex or Interactive Brokers, because when I explain what the allegations are and explain to you what they put the evidence into the complaint that I'll put in this video, it's going to be kind of freaky, but the main person, EISEN, because it's EISEN v. Apex, lives in Florida, he has to be representative of all those class members so that when he's deposed or if it goes to trial, he testifies, he would effectively give testimony that would apply to everyone who's been affected. So since it was everybody who got shut off from being able to buy the meme stocks on January 28th, it's a prime example for a class action lawsuit. But the nefarious thing is what they allege Apex did, and they actually put proof in the complaint of it. Apparently, Apex services Ally Financial, Stash, Public Investing, Tastyworks, M1 Finance, and Webull. So if any of you were using any of those, I'm going to put the name of the class action attorney in the description, because you'd actually be entitled to be compensated from this class action lawsuit if any of you held any of those stocks, GME, AMC, BlackBerry, Express, or COS, on January 28th, and were using any of those brokers or Interactive Brokers LLC and had your ability to buy shut off. I'm going to put the class action attorney's info in the description, because you could become a member of this class even after the settlement's reached, technically, and get paid for your losses of what you would have made had they not shut down buying. Because they actually included in the lawsuit actual text messages from Ally and other brokers saying that Apex arbitrarily shut off their ability to sell these stocks, the ones that I just listed. And then they went so far as to actually post an interview where Apex gave, where they explained that they had adequate capitalization to meet the NSCC's increased capital requirements, but they shut off the trading for 3 hours that day anyways, regardless of the fact that they met the capital requirements and there was no reason to shut it off. So basically, they're kind of dead balls on the hook for intentional market manipulation. Interactive Brokers is a little bit different. There's an allegation in there that I'll also put along the video, the picture of it. They increased their margin requirements by 100% for longs and 300% for shorts, and over 300% over what the NSCC was calling for, because the CEO in an interview said that he was afraid he'd be on the hook for the losses to the stocks. I don't really understand why he would think that, but he increased it so high that it made it impossible for anybody to buy. And apparently that's an ongoing thing, that he still has an increase to that if you're in a long position, you have to have 100% margin coverage. If you're in a short position, you need to have 300% margin coverage for any of those named stocks. So people who think that because of the Robinhood testimony that the reason all the trading was shut down was because of this increased margin requirement, this class action lawsuit that was filed on April 30th actually shows that if you were trading through Ally Financial, Stash, which is unfortunately the horrible brokerage account that I use, Public Investing Incorporated, Tastyworks, M1 Finance, which I also have, or Webull, which I know a lot of people use, they all use this Apex Clearing Corp, and they're the ones who, when you see what I'm going to link above as I'm talking, what's been alleged and screen captured, seem to be on the hook the worst for blatant market manipulation. And it wasn't an issue of raised margin requirements, because they have the CEO in an interview answering a question blatantly saying that they had adequate credit. So like I said, I'm going to put the link in the description of this to the lawsuit, the name of it, the caption of it, the case number of it, and I'm also going to put the attorney's information, so anyone who's watching this who was using Ally Financial, Stash, Public Investing Inc., Tastyworks Inc., M1 Finance LLC, or Webull on January 28th and were unable to buy because it was shut off, you can call the lawyer and become part of the class and get a recovery from this, because that's how it works. You're still entitled to do it. I know this isn't a normal video for me. I, typically analyze legal things, but this is a lawsuit and it relates to a stock issue, and Matt Kors specifically asked me during his stream yesterday to make a video about it. So I just thought everybody would be interested in knowing that if you use any of those brokers, you can call this lawyer in New York and tell him that you want to be a member of the class. The class can be an unlimited size. It only has a minimal size, not a maximum size. And the settlement that the court will approve will increase the more members there are. So my advice would be to call this guy. He's a New York attorney, but the class representative is in Florida, so it's filed in Florida District Court, but he was admitted pro hoc vice for the purpose of bringing this. So you can live anywhere, because federal court covers diversity jurisdiction and you don't have to do anything. The guy in Florida will take care of everything because he's the representative member of the class, and you'll just sit back and collect a check. So if I can help anybody collect any money because they were, messed over by their... Oh, they even put in a photograph that I'll show you of how exactly a trade goes from the broker to the clearing corp through, and how the trade works, to show how the clearing corp was able to shut the brokerages down so that they couldn't sell because the clearing corp shut them down. There's even a text from a brokerage firm, I think it was Ally, that said, with the clearing corp says we can't trade, we effectively can't trade. If they say we can't sell, we can't sell. And that I'll also put in the video so that you can see it. But I mean, they pretty much got Ally by the short and curlies in this. So if you used any of those brokerages, feel free to contact the lawyer below. I hope I helped anybody out. Best to everybody. Thanks.